Welcome to another episode of Living Justice, Living Leadership. I'm your host, Lee Fisher, Dean of Cleveland State University College of Law. You know, I've had the great privilege to live my life at the intersection of the public, private, nonprofit, and academic worlds. As a practicing lawyer, CEO of two large nonprofit organizations, and as an Ohio State Representative, State Senator, Attorney General, and Lieutenant Governor. And the lessons I've learned come down really to just two words: justice and leadership. That's why every week we'll talk to people who are walking the walk. We'll learn the leadership lessons of these highly effective leaders. Some are lawyers and some are not, but all of them have something in common. They are change makers. They are custodians of democracy. They are guardians of justice. They are living justice. And they are living leadership. Welcome, everybody, to my podcast, Living Justice, Living Leadership, but also welcome to the class that I teach along with two of my good friends, Kelly Tompkins, the Senior Advisor at Dixon Eaton, and Sharon Sobel Jordan, the President and CEO of United Way of Greater Cleveland. And today, the podcast will be featuring two very special guests. All of our students will be listening to this podcast, and during the appropriate time, they'll also be asking questions of our two guests. So at this point, I'm going to ask all of our students in the class, which is Leadership Lessons of Highly Effective Leaders, to turn off their cameras. In about 20-25 minutes, I'll ask you to turn them back on, and I hope you'll have a lot of great questions for our guest. Now, my first guest today is somebody who I've known almost my entire life. We went to high school together at Shaker High School. We graduated the same year, and we've been friends nonstop ever since. We've even played on the same softball team. And I would venture to say that no one would disagree in our high school class that the person who is the most successful graduate of the class of 1969 Shaker High School is my guest, Judge Dan Polster. I think those of you who know about the law know that the ultimate job in the law is being a federal judge. And literally less than 1% of all lawyers ever get to have that great honor. Judge Dan Polster, who went to Harvard College and Harvard Law School, has earned that honor. In 1998, he was appointed by President Bill Clinton as a federal judge. Just recently, he took senior status, but if you know anything about Judge Dan Polster, that really means nothing because he's just as active and senior status as he was before he was on senior status, and he'll explain to us today what that means. Judge Polster is a judge on the U.S. District Court for the Northern District of Ohio. Prior to serving as a federal judge, Judge Polster worked as a federal prosecutor in Cleveland with the U.S. Justice Department for 22 years, first as a trial attorney in the Antitrust Division, and then for 16 years as an assistant U.S. attorney, handling fraud and corruption cases. I think that perhaps the most important part of his resume, though, is not that he went to Harvard and Harvard Law School, but that he's an adjunct professor at our law school, Cleveland State University College of Law, where he teaches mediation, and it's one of the most popular courses in the class in the whole law school. He mentioned to me before we went on air that I had not invited him back. So tonight on this podcast, I'm publicly inviting him back to speak again in another academic year. Judge Polster, welcome.
Thank you, Lee.
Judge Polster, what we're going to do today is walk a little bit through your life and talk about how you became a federal judge. And then we're going to spend a lot of time, of course, on how you decide cases. What are the most difficult cases you've ever worked on? All of which brings us to the point where we want to extract leadership lessons from your life, both as a lawyer and also as a judge. So let's first start with you're a little boy. Did you know in elementary school that someday you wanted to be a federal judge?
Absolutely not, Lee. All I wanted to be was a baseball player. I wasn't as talented an athlete as you are. All right, but I just wanted to be a baseball player. I'm sure my parents knew that, by the time I was age 1 or 2, they had not produced a future major leaguer. I was uncoordinated, somewhat overweight, nearsighted, but this was my dream. And, my parents, to their credit, didn't puncture my dream. They figured, well, it's perfectly harmless, kept me out of trouble. I take my bat and glove up to the playground every day, or in the evenings in the summer, whatever, and that at some point I might figure out a plan B. Well, that moment came in sixth grade. Our coach for Little League was Al Rosen, the Hall of Fame third baseman for the Cleveland Indians.
Yes.
And then became a very successful executive. Why was he our coach? Well, his son was on the team, so he was the dad. And one day he said, guys, I'm going to teach you how to hit a curveball. And so he pitched these curveballs, and these weren't wicked splitters or anything, just slow, easy curveballs. And I can still remember this day. I saw exactly what the ball was going to do, what it was doing, and I figured, well, I can do this. So I get up there when my turn came. I could not make myself swing where I knew the ball would be. I kept swinging where it started. Forget foul ball. I didn't come within a yard of hitting this ball. I came home, came into the house, threw my glove down, and said to my mom, I guess I'm going to have to be a lawyer. It actually happened. And she, instead of saying, what took you so long? She said, oh, that's nice. And that's when I decided I would be a lawyer. I guess in my mind, this was a plan B. Everyone watched Perry Mason, but the show I really liked was not Perry Mason. It was The Defenders with E.G. Marshall. And what I liked is they took very tough cases and they lost most of them. But, they were interesting. They were challenging. They took defendant unpopular clients. And I thought, well, this seems like a good thing to do, that I might like it. And so my dream then became to be a lawyer. And I was absolutely certain of that until I was just about done with college. And back then, this was, 72, 73, everyone was going to law school. If you didn't know what you wanted to do or what you wanted to be, people said, well, go to law school. And so everyone was going. And I somehow thought, is this something I just seized upon when I couldn't hit Al Rosen's curveball? And I decided to take a year off. Now, back then, now most people do not go directly to grad school. Everyone is encouraged to take at least 1 or 2 years off and work, do something else. Back then, almost no one did it.
You're right. It was unusual.
Now,
you're right.
There was a good reason for it, because if you took any gaps, you went to Vietnam. Fortunately for me, I had both a high lottery number and I had childhood asthma, which made me fit for only emergency duty. So I took a year off and I worked in New York City, did some law-related work, and decided, yeah, I really do want to be a lawyer. And then I went to law school. So I had no idea of being a federal judge at all. It sort of evolved. I was in court a lot as a prosecutor, so I knew all the judges. I thought I knew what being a judge involved. I really didn't know. I saw the tip of the iceberg, which is the judge sitting on the bench, during a criminal proceedings or sometimes civil proceedings. So it sort of evolved that I figured, well, I'll give it a shot.
Well, you've taken us now to Harvard Law School. Now, since we have a number of our law students, obviously, watching and listening today, if you could do it all over again, what lessons would you give to our law students about things that you learned, lessons you learned as a law student at Harvard Law School? Did I stump you already?
No, I think I learned some good ones. I don't think I do too much over. One of the things one of the good decisions I made, which again, now it's automatic. Now everyone takes clinical courses. There are tons of clinical courses. Well, 50 years ago, there weren't. There were just a couple of them. And I took one during intersession. But my main activity was working for the Harvard Defenders. And there was a very good student practice rule in Massachusetts. And so we we represented defendants in the lower court, the district court, and these weren't obviously, major felonies, but we were their lawyers, and so we had clients, and we did everything a lawyer should do. The third-year students represented the clients. Of course, we had an advisor who oversaw everything we were doing, and then the second-year students assisted. And that was probably the best thing I did at law school. I really learned what it meant to be a lawyer. I developed an interest in criminal law, courtroom work. I had to deal with some serious ethical issues. It's one thing to learn about them in the classroom. It's another to actually see some of the challenges in actual practice. So again, it wasn't that common 50 years ago, but of course it is now. And I know Cleveland State has many very fine clinical programs for the students. So
we do.
I would encourage people to do that, and also seek internships, externships, summer jobs in areas that you think you might want to do, to sort of test those assumptions. And you'll either confirm them or determine, hey, I thought this was something I wanted to do, but I think I better go in a different direction.
As important as the classes that we teach are, I don't think there's anything more important than experiential education. And I think that lesson that you gleaned from your time in law school is even more true today. Now,
I remember a funny story.
Okay.
The first case I had was a young man who was picked up in a car that wasn't his. And sort of the lazy way they prosecuted people was charging them with use of a motor vehicle without authority. The police didn't have to prove that the individual stole the car, just had a car that he wasn't supposed to have. So it's a slam dunk case. All right, anyone would have just given up and urged a plea. But, we were law students. You don't quit. We were all budding F. Lee Baileys here. And so I went to work on research. And of course, there were no, LexisNexis, whatever. The way we did it, we went to the library, and there was something called the Decennial Digest. Lee, you're my age, so you remember these massive tomes that had, with key numbers, literally every case in the country over a 10-year period. And you pulled them out of the stacks and lugged them over to the Carol, and you sat and you poured through and you looked at your key number. And lo and behold, I found two cases that I thought helped me. There was a case in Hawaii. All right, remember, we're in Massachusetts here, Cambridge, Massachusetts. A case in Hawaii where someone used the argument that the car wasn't moving when they were faced with this charge, and won. And then, even better, a case that I learned that in New York State, the New York legislature changed the law because people were using that defense and getting off. They changed the law to make clarified that the state didn't have to prove that the car was moving. So, armed with these cases, I went into court, all prepared. I remember the Irving Younger was this famous professor, and they said that the first and most important rule of cross-examination is sit down and shut up, because you can make a fool of yourself. So I listened carefully to state's testimony. The police officer didn't say a single word about the car moving. There was one very unfavorable fact, which is the motor was running, and I didn't want to bring that out, but the police officer didn't testify to that. So after he finished, I stood up and I moved for a directed verdict. All right, we're almost never done, but I moved and I pulled out my New York case and Hawaii case and made the argument, and the judge agreed and threw the case out. Well, I thought I was the best lawyer in the country. So I advised everyone in Harvard Defenders that, I was the next top lawyer in the country. And for a month or so, I was, until my next 5 cases in a row, my client didn't even show up for court, 5 in a row. And people were saying, oh, Dan, you're such a great lawyer. Your clients have so little confidence, they don't even come. So I didn't brag anymore, but I learned a lot from both.
So you graduate law school. How do you decide what you're going to do next in terms of a career choice?
Well, back then there was sort of a not so subtle, atmosphere at Harvard that, if you have a Harvard law degree, you should be a Wall Street lawyer. That's what you should do. And, I thought that was fine. And a lot of my friends were doing it, but I really didn't want that. I had always had in my mind government or public service, and I really wanted that. So I applied to the Department of Justice through the honors program. That was the way you got in. And here's another true story. Who interviewed me in 1975 for the Department of Justice honors program but Antonin Scalia?
Really? Okay.
Yes. Justice Scalia was not a justice then or a judge. He was one of the top officials at DOJ under President Ford. And he had gone to Harvard Law School, and he came back to interview. So I came into his hotel room where he was sitting at his desk. He was looking down at some papers. He never looked up at me. I didn't sit down. I'm not even sure I shook his hand. Without looking up at me, he said, "If you're hired, will you stay at least 3 years?" I said, "Yes, sir." And he said, "That'll be all." And I turned around and went out. It was no more than 20 seconds. And I was crestfallen because this was the job I really wanted. And some of my classmates said they had these long philosophical constitutional law discussions with Mr. Scalia. And I was racking my brain to figure what could I possibly have said or done wrong to offend him. And I got hired. I guess he could make up his mind quickly. Maybe he was looking at my resume. I don't know, but I got the check mark, and that began my career.
I'll bet you it was your clinical experience and that one case you won.
Yeah. Well, I didn't have that on my resume, trust me.
Okay, so you're there for 22 years. It looks
Right.
to me like you're going to be lifelong, and then
That
all
was
of a
my
sudden,
plan. That really was my plan. I was going to stay. I would have been eligible to retire after 30 years. And, I wasn't going to retire, but I was probably going to leave government service. And then I was actually thinking about teaching, I don't know, doing something different.
were there any particularly memorable cases that you worked on before you became a federal judge and you were at the Justice Department that you want to talk about today so we can better understand what you did as a litigator?
Well, I had, first I was doing fraud and corruption cases at the U.S. Attorney's Office, and they were tough cases. I closed far more investigations than brought indictments, because the first principle of federal prosecution is that you don't seek an indictment unless you believe you have admissible evidence which will bring a conviction, which will prove beyond a reasonable doubt that the defendant committed the crime. It's relatively easy to get an indictment, very hard to get a conviction, and you don't start it unless you think you can win. And so I closed many cases, but I had a number of challenging ones. Probably some of the big ones are ones I lost. All right, and I learned some humility. I had a very big case against a group of podiatrists who were charged with doing millions of dollars of fake and unnecessary surgery on patients. And, some eyewitnesses were not as good on the stand as I thought they would be. And so the case didn't end up so well, but I learned a lot from it. I would still bring it again. I think I might do some things differently than I did.
What would you do differently? Maybe prep the witnesses better?
I think that I didn't appreciate that the fact that Blue Cross Blue Shield was so involved in the investigation, and they were also the principal financial victim because they had paid most of the patients had insurance, and so they were the principal victim financially. Of course, the patients were victims, but the financial impact was on Blue Cross, and they were very heavily involved in the investigation. And I didn't appreciate how that would play in front of a jury or what the defense attorneys would do with that. So that was a good lesson.
So part of it is thinking not one step ahead, but 2, 3, 4,
Right.
5 steps ahead and try to
Right.
anticipate. Okay, that's a good leadership lesson
and
right
also
there.
How difficult it is, to bring a criminal case that is premised in large part on unnecessary surgery, because again, it's a medical judgment, and
Right.
And it's very hard to get the kind of testimony that will convince a jury beyond a reasonable doubt.
Any other cases, either when you were working in the antitrust division or when you were focusing on fraud and corruption, that are worth talking about before we get to your career as a federal judge?
No, I think that the foot care case is a pretty good one, because we all learn more from the things that didn't turn out so well than our successes. You think about them more, and you think back, well, what maybe could I have done better or different? Which you don't. When things go well, you say, first you say, well, I'm great. I did everything right, even though there might have been a lot of luck or coincidence, but you just assume it was because you did it right.
Which is why I think that after you make a decision and after something is closed, whether it's a success or a failure, you do a post-mortem. Right. Because even if you won, there might have been ways you could have done better. And if you've lost, you certainly have a lot of lessons to learn. And very often we just close the door and move on to the next thing, rather than thinking about, wait a second, let's take a deep breath and talk about how I can learn some lessons from this so I don't repeat the same mistakes next time.
Right.
I said at the beginning of our interview that I think most people in the legal profession would say that the ultimate job in the legal profession is being a federal judge. But most people have no idea the backstory about how somebody becomes a federal judge. And although the stories are obviously different, tell us exactly how it is that you became a federal judge.
All right. Every one of us has a backstory, Lee. And any federal judge who looks you in the eye and says there was not a lot of luck involved in his or her appointment, I don't think is telling the truth. There are many, many, many people who are very well qualified and would be very good judges and never get the opportunity or aren't chosen or aren't picked. You need to be in the right place at the right time. I mean, in my opinion, there are two ways to become a federal judge. One is if you yourself have a lot of really strong political connections, because it is a political appointment. You are appointed by the President of the United States, and generally you are recommended by one or both of the senators in your state. All right, these people are politicians, and your background. Politicians listen to other politicians or people who've supported them or politically prominent. So you need that kind of political capital yourself, or you need to have friends who have that. Well, I was in the second group. As a career federal prosecutor, I wasn't allowed to be involved in any politics. I couldn't give money to candidates. I couldn't attend fundraisers or political events. I could vote, and that was about it. I did a lot of work in the community, the nonprofit community, and those of us who do it, one of the best things we get is friendships that we meet people who are doing the same kind of thing, and they're great people, and we wouldn't have met them otherwise. Well, it just happened that a few of the people I had met and worked with were the kind of people who could pick up the phone and call a senator's office and speak to the senator because they knew him or her personally, and they went to bat for me. I guess because they thought that I could do the job. And without that support and friendship, I wouldn't have had a chance. Even with that, I was a long shot because, again, I didn't have I wasn't well known in political circles at all. No one knew me in political circles, but with their support,
I knew you.
well, right, and you were one of the people I called. Okay, I was no fool. I mean, a few people like you who did have that kind of access and knowledge. But as you know, because it is political, it's not likely that a Democratic senator is going to recommend someone who's a well-known Republican. All right, so I was a registered Democrat. I wasn't involved again in politics, but so and there have to be vacancies. There have to be vacancies, and there are only vacancies when a judge basically retires or takes senior status, and they don't come open that often. And sometimes and it used to be, when we started practice, Lee, federal judges were all middle-aged or older white men. That was the whole court. There has only been diversity on our court for 40 years. The same day in 1980, President Carter appointed Ann Aldrich, the first female on our court, and George White, the first African-American in 1980. So it's 42, 43 years ago. So,
and by the way, I should add that George White was a graduate of our law school, and Ann Aldrich was the
right.
first tenured female professor at our law school.
Right. And both became excellent jurists. But again, we had no diversity before then. And so senators are looking for people now in a certain age group because they want a judge who's going to be on for a long time, ideally. So you got to be the right age. And so there's just a whole lot of luck. And you put yourself, you self-nominate. And the senators, at least in Ohio for the last quarter century, have appointed a merit selection committee, a screening committee. Back then, there were just 5 people. Now there are about 20. And they review all the applications. It's a daunting application. They use the application form that the Senate Judiciary Committee uses. So anyone who's not serious about it will drop out just for not wanting to take the time to do that application. They screen the applications, they decide how many people to interview, then they interview them and they make recommendations to the senators. And then the senator makes a recommendation to the president. You go through a background check, FBI, et cetera, and then the president makes the nomination. And then you only move forward if the Senate Judiciary Committee gives you a hearing. And that's a whole other story. And it took me a year to get a hearing. But then I finally got my hearing. Once I got the hearing, then it was fairly quick to get a full Senate confirmation vote. And once that happened, the president signed the commission, and then I became a judge.
Well, you and I know a lot of backstories of a lot of federal judges, and you're right, each one's different, but I think it's fair to say that although there may be a measure of luck, there's a lot of persistence and making sure that you touch every base, and also right. A lot of focus on, is this person going to be a great federal judge? And clearly you have been. So now let's jump to your career as a federal judge. And although you've literally handled thousands of different matters, I want to jump to the one that you're best known for. I sent to our students in this class a copy of an article that appeared a few years ago in the New York Times. And I'm going to read just the first sentence of that article. It says, Judge Dan Polster for the Northern District of Ohio has perhaps the most daunting legal challenge in the country, resolving more than 400 federal lawsuits brought by cities, counties, and Native American tribes against central figures in the national opioid tragedy, including members of the prescription painkillers, makers of the prescription painkillers, companies that distribute them, and pharmacy chains that sell them. And he has made it clear he will not be doing business as usual. I know that this case is not over yet, so there are certain things you cannot talk about. But
And that was at the very beginning.
At the very beginning. You are well known for the fact that you believe whenever possible you settle a case instead of trying it. So let's begin with that premise as how you approach this case and go from there.
All right. The 400 cases morphed to 3,000. So I now am overseeing 3,000 cases. This is the hardest thing I have ever tackled professionally by many, many orders of magnitude. There's never been cases like this in our court system. I knew immediately it had the potential to literally crater our court system because courts couldn't handle it. I mean, each of these cases takes months to try, and there were 20 or more defendants in each one, and the complaints are 100 pages long, and of course. Typically, as you know, a lawsuit is about something bad that's happened in the past. The plaintiff thinks the defendant did something wrong and wants some money for it. This was in the present. When I started this, a little over 5 years ago, our country had been literally replicating the Vietnam War casualties year after year for 10 or 15 years. 50,000 or more people were dying of drug overdoses, and they were largely young people, the age of our students in this class, not people of our age. And many of them had started on prescription opioids, become addicted, gravitated to street drugs, and were dying. And I remember saying that, in the first meeting, I had over 100 lawyers crammed into the courtroom, that just while we were meeting, a couple hundred Americans were dying, were going to die. And I said that it didn't really belong in our branch. I had it because the other two branches, candidly, hadn't done much for years and years. It was no secret. All these people were being addicted and dying. And I said, I predicted that the plaintiffs are going to win some of these cases. The defendants are going to win some of these cases. So many people are dying. We should just sit down and try to settle this right now. And I got unmercifully attacked, beaten up every which way in that. And that attracted the attention of this New York Times reporter, and that's why she came out and interviewed me. And what's also interesting, it happened the day that she came out, I was teaching my class at Cleveland State Law School, and she came and sat in on the class, and there was a picture in the article of me with Matt Fitzsimmons at Cleveland State. I think I had to get the school's permission.
That's a great photo.
Allow her to come in, but she followed me around, and I was teaching, and well, that was, I don't know, it was naive to say it. People have asked me, if I had to do it over again, would I have said it or done it that way? I don't know. I very quickly had to reverse tack because it became clear that no one would talk seriously about settlement on either side unless it was in the context of a real case that was being worked up and was going to trial. So that's what I did. And a multi-district judge can only try cases in his or her district. I'm overseeing now 3,000 cases from all over the country.
By the way, we should call these are called MDLs, right? Multi-district litigation. Yeah.
Right. The only case that a judge can try is one that's venued in his or her district. So I had to pick one from the Northern District of Ohio. So I picked one brought by the, Cuyahoga County and Summit County against the manufacturers, distributors, and pharmacies. And that was the first case that we worked up, and I dealt with all the motions and all the Daubert hearings with the expert witnesses. And we picked a jury. And we were to start Monday morning, and it's Sunday night, midnight, the case got settled. That was the first one.
What was the result of the settlement?
Well, the settlement was about $265 million. And people were coming up to me saying, Dan, great job. You got all this money for Cuyahoga County. And I said, well, that really wasn't my objective, because we had done all the work. And the whole point was to see, how these novel theories and the defenses would play out in a real trial. Because, of course, the plaintiffs were saying, well, we've got a terrific case. And the defendants were saying, it's no case at all. And the only proof is to see how they play out and see how the witnesses really testify and what the jury's going to think of all this. And we'd done all the work and the thing settled. So we learned nothing. But that led to that, and then a number of other cases being set for trial, and some have been tried around the country. We have now, 5+ years later, there are 9 global settlements totaling about $50 billion.
Amazing.
So, well, it's been a lot of hard work. I've been reversed many times by the Court of Appeals. I made plenty of mistakes. I've tried to learn from them, but we've managed to do it. Fortunately, I've had the best lawyers in the country, and most of my suggestions come from them when I listen to them and, try to synthesize things. But it's been a monumental task, managing it. And then, of course, dealing with these are all novel theories. And so there's no, when I tried my case, I finally did have a trial last year. There was no model for the jury instructions. I had to come up with them myself. Obviously, I read what the lawyers had said, but of course, each side had many, many disagreements and differences with the other side. So I had to pretty much come up with them myself. And it's now on review by the Sixth Circuit, and we'll see what they do with it all.
Judge, as you know, we have a class who's listening today, so I'm going to ask all of our students now to put their cameras back on, because I'm going to give them a chance to ask you some questions. I'm looking for a volunteer who would like to break the ice and ask Judge Dan Polster the first question. I've got lots of others if you don't have any, but I want to give you the chance to ask a question too. Anybody have any questions? Now, remember, I can cold call you, which would be really tough, because then everybody who's watching this podcast will see you being cold called. You don't want that to happen, right? Anybody? Okay. Let's go to Jake Kelly.
Hi, Judge. Thanks for your time
Hello,
today.
Jake. Sure.
So when you were taking the opioid cases, I imagine, I know you spoke a little bit about, you're getting flack from both sides, but as a former prosecutor kind of dealing with these cases, did part of your, I don't want to call it a leadership crisis, but part of the decision-making going into that, did you worry about bias at all? Against some of the manufacturers or anything of that? How did you kind of counteract some of that going into it, if any?
Yeah, I had been a judge for a while, so I think I had showed, probably when I first came on, Jake, people thought, well, this guy's been a prosecutor for 20 years, he'll be biased toward prosecutors. So I was, I worked very hard to make it clear there was a level playing field. And I think that the defendants thought I was being biased against them when I suggested settlement right away. That's how they took it. And maybe others did. I didn't really look at it that way. I knew this. This litigation had the potential to bankrupt every defendant in the case, except possibly Walmart, because they're so big. And, we're a drug-dependent society. Millions and millions of Americans are only alive today because they're taking drugs which take care of their heart or their blood pressure, their diabetes or whatever, and they're dependent on it. So they need these companies to keep making the drugs. They need the distributors to distribute the drugs. They need the pharmacies to dispense them. So if we bankrupted everyone in the industry, where the heck would we be? I wasn't, I think people I hadn't appreciated that when I immediately talked about settlement, the defendants would believe I was biased against them. And so I probably, if I would do it over again, I think I would take some pains to maybe say it in slightly different way.
Right. In other words, the same objective and goal, but approaching it in a different way.
Right.
Right. Let's go next to Abby Jones.
So I had a very similar question to Jake about avoiding bias, but I saw, and please correct me if I'm wrong, that you had mediated the settlement between Cleveland and Tamir Rice's family.
Right.
And
yes.
I'm wondering how that differs from overseeing litigation. I'm sorry, I'm not that familiar with mediation.
All right. Well, that's what I teach, Abby. And if you're, since the dean has now invited me back, Matt Fitzsimmons and I will be teaching in the next spring, the spring of
Fantastic.
24. We're on. We've done it a number of times, and this gives me a chance to talk about one of the things that I like the most about my job is mediation. Some judges do it, some don't. When I was in law school, I don't think mediation existed, Lee. I don't remember it at all. Now it's very common. You have a trained person who helps the parties reach a voluntary settlement. Unlike arbitration or litigation, where someone makes a decision and you got to live with it, like it or not, mediation is completely voluntary. The mediator uses his or her skills, good listening skills, earning the trust of both parties, asking good questions, eliciting information. What I try to encourage the parties to transform a fight where someone's going to win or lose into a problem to be solved. And that's when people, get creative to solve a problem. You're in a fight, it's fight or flight mode. You're only using half your brain. You need to use your whole brain. So Tamir Rice, that was not my case, was on the docket of my colleague, Judge Solomon Oliver. He asked me if I would mediate that. And if a colleague asks me to help out, I'll always say yes. That's how we're on a team together. And it was a very, very, very difficult case. Without a doubt, the toughest cases are when someone has died. And I don't know how many times, there are a lot of things I can't talk about, but probably more than 10 times during that long morning, afternoon, early evening, I said, the one thing we are not doing, we are not putting a monetary value on the life of a young boy. In my tradition, and I hope in every tradition, a life is of infinite worth. We can talk about the value of a lawsuit, how a jury might think about certain claims, legal issues, qualified immunity, all of that, what the chances are of overcoming it. That we can try and quantify, because I knew how I would feel if this were my son. And my first reaction is, I'm not putting a price tag on my son's life. We'll just go to trial. Whatever the jury does, they do. I'm not going to be doing this. And so it was very hard. Fortunately, we had a mayor, Frank Jackson. I don't think it's a lot of credit. He was a guy of very few words. If you'd ask him to speak, it would be one or two sentences. But, there are people who are all sizzle and no steak. Frank Jackson was all steak and no sizzle. And that's a lot more important for a leader. We're talking about leadership. He could make tough decisions, and he decided that this case had the potential to tear the city apart. And it would have gone for years because the city had, qualified immunity. That's a whole other subject. I'll cut into Justice Stewart's time, and I'm not going to do that. But this would have been a very difficult, legal issues were very difficult here, and this would have dragged on for years. And he made the decision, and again, it's easy since the case would have taken years. kick the can down the road. If there was any money paid, it would have been, someone else. But he made the decision, I'm going to pay the money to get this case settled quickly. And I without that, the case wouldn't, I couldn't have done anything.
Judge, we have time for two more questions before
Okay.
I ask you a final question. We're going to go to Abigail Klein next.
Okay.
Judge Polster, thank you. So you spoke briefly right there about a leadership habit and one of being decision making. And as you know, and as you said, we're in a leadership class.
Right.
And I know you said in mediation cases, you had to train yourself to lean into the emotions. So would you
Right.
think the most important leadership traits that you could possess as a judge is the ability to lean in one's emotions, lean into the emotions of both the client or defendant? And if not, what would you say would be the most important leadership trait?
For mediation, definitely being a good listener, being empathetic. As lawyers, we're sort of, we're trained to push emotions to the side, just get to the facts. Well, as a mediator, as you said, you've got to lean into them. I mean, sometimes I feel like a rabbi or a priest or a therapist in these mediations. People yell, they cry, and that's okay, because they're able to get those feelings out. And if they suppress them, you'll never get to a settlement. I would say this, I mean, a good judge and a good leader, you need three things. You need a brain, you need a heart, you need something below the belt. And the brains you can actually borrow. I mean, not completely. You've got to have some basic intelligence, but there's smart people around. You can read, you ask questions. The other two, you've got to have yourself. You need a heart. You have to be an empathetic person to be able to put yourself in someone else's shoes, someone who's different than you. You obviously need some guts, because it's not easy. You make some tough decisions that maybe no one likes. You make some that don't come out so great, and you can't beat yourself up over it, or else after a certain point you just quit. And then lastly, I think maybe the most important attribute is humility. One of the hardest things about being a judge is everyone defers to me. It's yes, Your Honor, yes, Your Honor, all this crap. And, you can get a swelled head. You think, I got a lifetime position. I actually have no boss. There is no one who can tell me what to do, when to come to work at all. I mean, a good leader, you got to understand you're just flesh and blood. You're going to make mistakes. You can't be arrogant. You need to treat people with dignity and respect. And if you do that, they'll forgive almost any mistake you make. But you're not infallible, and because if you act that way, you won't listen to others. So, the brain, the heart, the guts, and then maybe first and foremost, humility.
Let's go next to Kelly Tompkins.
Well, I'll just say hi, Dan, instead of
Kelly?
Your Honor.
Okay,
How's
we've
that?
known each other a long time. That's fine.
No, I appreciate your time. I was really struck, part reading the article that Lee sent to us and then listening to your comments, the decision-making process for a judge in a courtroom versus my world, which was corporate decision-making, and this is where I think lawyers bring such unique skills to any organization or environment, and that is assessing credibility, having the opportunity to see a witness cross-examined to assess the truth. The whole dynamic of that courtroom decision-making process. Yeah, there's posturing. Lawyers have personalities, and some are more theatrical than others, but at the core, it's a pretty good mechanism to get to the truth and assess credibility. Whereas in my world, a whole lot of posturing can go on, and
Right.
a whole lot of political influences, and there's not necessarily that opportunity unless, as a lawyer, you say, you know what, I may be in a business role, but what I learned in law school is the ability to ask questions and be inquisitive and assess that. So I think for students that may not go into a courtroom environment, those skills can translate into any environment you're in as a decision maker and a leader. So,
Yeah,
thanks.
thank you. I think that's, our system is not perfect, but I think it's the best system that men and women have designed. And the jury system works, but the real pressure is on the judge. If I do my job, the jury system works. And so when I'm at trial, Chief Justice Roberts, said at his confirmation hearing, all judges do is call balls and strikes. That obviously is not the case for Supreme Court, but it is often the case as a trial judge. And the key is not whether my strike zone is wide or narrow, but whether it's the same for both sides. And I work very hard at that because it's very important that everyone feels they're getting a fair shake, the lawyers, the litigants, the public, that I haven't, prejudged the case and it's a fair trial. And I keep it moving because jurors will lose focus and attention. So I set time limits for civil cases and I try to do them fairly, but lawyers work to deadlines and you're not going to win a case with junk. You go with your best stuff. And then I work very, very hard on the jury instructions. Inevitably, there's got to be some legalese because it's legal, terms, but I try to make them intelligent enough for ordinary people to follow so they know what the heck they're supposed to do. And then if I do all that, and the product of having in federal court, you've got to have a unanimous verdict. And the beauty of that is that people have to do with what sadly we're beginning to lose the ability, which is to sit down and listen to people who maybe look different than we are, think differently, and maybe have seen things a little differently and talk to them. You can't just say, the hell with you, I'll outvote you 10-1. Either I've got to convince you or you've got to convince me. And that product makes for, I think, a pretty good and accurate decision. Not perfect, but if the judge does his or her job, I think we've got the best system that anyone's designed.
Judge Polster, something that you and Ohio Supreme Court Justice Melody Stewart, who will be our next guest, have in common is this. We all have to exercise judgment every day in our lives. But there are very, very, very few of us who exercise judgment virtually every day that can affect the arc of someone else's life, whether it's a sentence or a mediation, no matter what it is. The power and influence you have in your hands is extraordinary, more than any other office in the world. I would argue even more than President of the United States in some ways. Because when someone is before you, literally, it's at a turning point in their life, usually. So my question is this. If I could put you on the spot and ask you for 3 leadership lessons you've learned over the course of your career as a lawyer and as a federal judge, what are those 3 important lessons you'd like to leave with all of us today?
Well, one comes to mind. I don't know if, all right.
If you keep talking, you'll probably come up with 2 more, I'm sure. Okay.
The best things I have done as a judge are the things I haven't said and done. So think before you speak and act. All right, that really is number one. You have an awesome power, but often the best thing is not to use it. Okay. I'm the one who's got to keep things, on an even keel. Litigation's a full contact sport. The last thing you need is a judge to throw gasoline on a fire. I got to calm things down. I got to be under control. No matter how I'm feeling inside, there's a way to act. And I guess that's lesson number 2. I put that robe on. It's a reminder to me that I'm representing something much bigger than me. I mean, I can say and do whatever I want on the bench, okay? But if I act in a, undignified way, I'm bringing disrespect on the whole legal system, because to those litigants, their case is the most important case in the country. They will make their judgment about our American system of justice from how their case proceeds. And I need to remember that. And so, putting myself in the shoes of the people in front of me and working hard, and then trying to treat everyone with dignity and respect. I mean, that's certainly my objective. I'm sure there are some days I've come up a little short, but that's, really, I've learned that if you work hard and you treat people with dignity and respect, they will forgive almost any mistake that you make. And those two things we can all do. We can do that. There's a whole lot of things we can't control, and a lot of things we want to do, intend to do, it may come out, some other way. But we can always work hard, and we can always treat people with dignity and respect. So maybe that's 2 or 3 things. How did I do?
You did very well. I'm going to give you an A in our leadership course today, and I'm going to try to quickly summarize the leadership lessons that I have heard today from your extraordinary career. And I regret that we didn't have 3 hours to do this. We only had about 50 minutes. But number one is that leadership has a number of different elements to it. First, of course, is brains and wisdom and confidence, and competence, I should say. But if that's all it is, it's not really leadership. You also have to combine it with heart, empathy, and compassion, and also guts and courage and confidence. And then perhaps the most important element of all is humility. Understanding that despite how much power you may have in a particular situation, knowing the limits of that power and understanding the limits of the power is extremely important. So I would say that's lesson number one. Lesson number two, as you said, is to think before you speak. Very often we're quick to react to something emotionally, very quickly. We all can think of times someone has sent us an email that made us angry. And our first instinct is to press reply immediately. And usually what I do is I have a large parking lot of emails that I've never sent, thank God. Because if I had, although I might have felt better at the moment, I would have felt awful days or maybe even seconds later. So think before you act and use some discretion, which you do, obviously. And number 4, recognize that as a lawyer, but particularly as a judge, you're not just representing yourself, you're representing in many ways the rule of law and the legal system. And that's particularly true as a judge. And then number 4, I'm giving you 4 lessons, not 3,
Okay, great.
is that no matter what the decision is, even if it's going to make someone unhappy, if you have treated them with dignity and respect, they're far more likely to accept that decision. And in the end, that may be the most important lesson of all the ones you gave today. So Judge Dan Polster, I want to thank you. You've had an extraordinary career. And as far as I'm concerned, it's going to extend for another 20, 30 years. Even though you're in senior status, you're in fantastic shape. I didn't tell everybody, but I just had lunch with Dan Polster the other day, and he rode his bike. He's always on his bike. I, on the other hand, take my car. I'm not in half the good shape as Dan Polster is. That's why I say he'll be with us another 20 or 30 years. So, Judge Polster, thank you for a great, great lesson today in leadership and a phenomenal career as a judge that's going to continue for many years to come.
Thank you very much, Lee and Kelly, for inviting me, and thank you to the students, and good luck with all of you. I hope I see some of you in court soon.
I'm not sure they feel that way, at least not as a defendant anyway.
No, as lawyer. As
a lawyer, yes.
Great.
Let's just make that clear. Do you want to see him as a lawyer?
It's been a real thrill seeing some of my former Cleveland State Law School students appear in court and do a terrific job.
Absolutely. Judge, thanks again.